Good afternoon, everyone, or good morning, depending on where you're calling in from. This is Patrick Zanella, and I'm the Security Practice Lead here at Integration Partners. And thank you so much for joining us to go over a very timely topic for those folks who are doing business in or with the state of New York regarding the regulation they call DFS 23 NYCRR 500. So here to talk about kind of topics we're going to talk about today is really, what it is, why you should be aware of it, and kind of things to be aware of with this new regulation, which was released and went into effect earlier this year. So in addition to myself, I have Jeff Miller, who will be presenting a majority of the content today. He's our lead security architect. And just a little bit of background about who Integration Partners is. We're a national provider of both voice, data, and security technology products and services to the marketplace, handle several hundred customers across the U.S. We've done a number of these engagements specific to this DFS requirement and regulation. So we felt in speaking with those customers, many of them did not know that they were under the obligation of having to comply with this. So we felt it would be helpful to deliver this type of content in a very say unbiased or just a informational way. So really the goal of this presentation was scheduled for 30 minutes, and I'll see we're going to go over that. But just kind of what it is, why you should be aware of it, and then some compliance dates, and then we'll conclude with some Q&A. So with that, I'm going to transfer this over to Mr. Miller. He can take us through the presentation, and I believe everyone should see the presentation. If not, let me know, and we'll do our best to accommodate. And with that, Jeff, I'll turn it over to you.
All right, much appreciated, Patrick. Again, thank you everybody for joining today. The audience, the target audience, hopefully you fall within one of these three categories, is anybody who needs to comply with this new regulation or is interested in the new regulation. As Patrick said, it was put into effect earlier this year, but even if we backtrack it to, you always want to go back to what is the root of this, and why did somebody all of a sudden decide that we needed this new regulation? So if we track it back, the New York State Department of Financial Services was a consolidation of New York State's banking and insurance departments in 2011. So under Andrew Cuomo, they consolidated along with various other New York State entities, consolidating in an effort to save money. The DFS in 2013 and 2014 put out a survey of 43 institutions, and their goal was to better understand the cybersecurity posture of New York's financial services marketplace as a whole. So financial services companies in New York are responsible for a large portion of the state's gross domestic product. Improper security controls could lead to large losses in state and private income. So obviously, having such a large impact on the GDP, this isn't the kind of thing where we can look the other way and hope these organizations have their stuff together and are doing their due diligence. We have to kind of enforce at least some kind of framework for companies falling under DFS to follow. And so that's kind of the heart and soul of this. The DFS wanted to get a baseline of the cybersecurity posture of these companies. So in order to do that, they ask questions like, is there an existing information security framework already in place? Are people doing regular penetration testing? Is there budget set aside for cybersecurity? Do people generally have a plan for how to handle cybersecurity incidences or breaches? So based on this survey of these 43 institutions in 2013 and 14, this letter here, which I just have a snippet here on the screen, in early 2015, is a letter that basically released 16 cybersecurity guidelines. So between early 15 and March of this year, the DFS worked with lawyers, worked with insurance companies, worked with banks and financial companies, and they all put their heads together and said, look, we realize that there's issues. We realize that we're grossly underperforming in cybersecurity in many different areas. So because of that, they came up with these 16 guidelines, and from the guidelines were born the regulation that Patrick mentioned earlier, which is the 23 NYCRR 500. So it's a cybersecurity law And the people who need to adhere to it are the people that you see on the screen. So hopefully you are one of these people if you're joining this webinar. So organizations that must comply with the new regulation include anyone operating under or required to operate under a license, registration, charter, certificate, permit, accreditation, or similar authorization under New York State's banking, insurance, or financial services law. So I've got some examples here on the screen. Banks, trusts, credit unions, insurance agents, insurance brokers, mortgage, investment, holding companies. You know, these are just some examples. This is not an exhaustive list. And if you're unsure of whether you should comply or not, it's best to get legal advice from your lawyer. We're pretty sharp people. We know the law pretty well, but we are not lawyers. So it's important that you do get that perspective as well. We happen to be very good at helping people attack the cybersecurity needs within the regulation. We have worked with half a dozen lawyers, but again, we're not lawyers. So make sure you're talking with, getting legal counsel in terms of if you need to comply. Now notice here we didn't say where organizations, you know, we're talking about what organizations here. We didn't say where the organizations need to be in order to comply. So we'll touch on the where later on. So what really is in this law? The law in totality includes the things in the left-hand column and the right-hand column. So there's a number of different points here, and we've just summarized them, broken them out. And there's two types of organizations who need to comply with this new cybersecurity regulation. The first type of organizations is your larger companies, and they have to comply with the entire regulation. The smaller companies are what we call limited exemption, and those folks have to only comply with the stuff here on the left, okay? So if you are an organization that's larger, you have to comply with everything, and limited exemption, you have to apply with just the things on the left. And what is a limited exemption? The regulation defines a limited exemption as a covered entity with fewer than 10 employees or less than 5 million in gross annual revenue or less than 10 million in year-end total assets. Notice those aren't and statements, okay? So it's important to know, I'm highlighting the or there, less than 10 employees or less than 5 million in gross annual revenue or less than 10 million in year-end total assets. If any one of those applies to you, you are a limited exemption organization. You only have to comply with the items on the left. If none of them apply to you, you have to comply with the entire regulation. So some of those things here are listed on the screen. So what does the law tell us we need to do? It says that we need to have a cybersecurity program. Section 500.02, 500.03, there are 14 named policies within that section, things like access control, things like incident response, data retention policies and such. So there's a set of 14 policies that the law says you have to comply with. It deals with access privileges, so most people are dealing with Active Directory. So how are we restricting right access for folks, and what happens when they leave, what happens when they're onboarded, what if they're fired, what if they move departments, you know, how are we handling access privileges? So that gets its own section. 500.09 there is really the big lift, and we're going to really get into the risk assessment and what it is in more detail than the other sections, because the risk assessment is really the meat and potatoes of this entire regulation. Just like it is with HIPAA. So if any of you are familiar with the healthcare law, HIPAA, the main component of that is a risk assessment. And from the risk assessment, then we can be intelligent in knowing how we should shape our policy. And once we have decent policy in place based on our unique risk, then we can begin to spend money on technical controls appropriately. We don't want to screw up and do that backwards like a lot of companies do. We don't want to throw a bunch of money at shiny firewalls and endpoint protection, then wrap policy around it, and then do a risk assessment after the fact, because doing that is the reverse order of operations. So just like, in mathematics, we have an order of operations, it's really important to do things in the correct order with this regulation. The risk assessment, this is my personal opinion, should be done first. You're going to see on the next slide that there are dates for compliance, and the risk assessment isn't listed as the first thing that you need to do, but I'll explain why it is the first thing you should do. Some of the things here on the right, so if you're a larger organization or one that's not considered limited exemption, you need to have a CISO, or a Chief Information Security Officer. That could be somebody in-house. It shouldn't be willy-nilly. It shouldn't be somebody who you're throwing extra work at where they can't handle it. It should be somebody who's got security background, who can speak the language, who can present to a board of directors on a regular basis annually. So we don't take that lightly. If you have somebody in-house who can do that, that's fantastic. If not, you should consider outsourcing it. And we'll talk about options there as well. Penetration and vulnerability assessments are also a component that needs to be done for your larger organizations. The new one, and sort of the big thing here that no other regulation to date other than Department of Defense has, is section 500.12, and that's your multi-factor authentication. All right, so these days everybody's got a username and a password. Multi-factor authentication, simply put, is adding another level of authentication, such as a token. That could be a key fob with rotating digits. It could be your smartphone has an authentication app like Google Authenticator. It's just another layer on top of a password to help you authenticate into Windows, into your email, into a web application, whatever workflow you're getting into. Passwords these days are not enough, and New York State is the first state to have a state-level regulation on multi-factor authentication. And I think what we're going to see is regulation creep over time, where MFA becomes kind of baked into other regulations, whether it's PCI or HIPAA or whatever new one comes out tomorrow. So again, the big lift here is the risk assessment. Whether or not you're a limited exemption, you have to do the risk assessment. Even though it's technically not due until March 2018, it should be done first. This slide here talks about the dates of when these things need to be in place. You'll notice that the date that I have highlighted in orange here is the earliest effective date. Okay, so the things that you see that are in orange typeface, these need to be in place by August 28th, 2017. So what are we talking about, a month and a week now? So in the next 5 or so weeks, DFS expects you to have a cybersecurity program, policy, CISO, access privileges, risk assessment, and then so on, the other things in orange there. Now, do I think that they're going to immediately start sending foot soldiers out and knocking on people's doors to hold them accountable immediately? No, I don't think that's going to happen. Does that mean you should delay and pretend that you can kick the can down the road? No, you should, because that's not being a good business owner. It's not good due diligence. And if you are breached between now and then, you're going to be held accountable. Okay, so yeah, there's going to be some wiggle room, but no, I wouldn't treat that as a license to disregard the regulation altogether. It was just like HIPAA. HIPAA has been around for 12 years now. In the last several years, 5-10 years, it's really gained momentum. In the last couple of years, we're starting to see multi-million-dollar fines for companies where they're leaving unencrypted laptops in the back seat of a cab, sorts of things like that. So we don't want to be in that boat. We need to know our risk. Now, the reason I have risk assessment highlighted is that even though it's not technically due until March 2018, it needs to be done first. And why am I just staking that claim and making that fact? It's because you really can't have an effective cybersecurity program without understanding your organizational risks. So the whole point of cybersecurity is to reduce risk. If we don't know what our risk is, how can we say how we're going to go about handling risk and reducing it going forward? You can't. So the risk assessment should come first, even though DFS says it doesn't need to be done until March 1st, 2018. It even says in the regulation, quote, the cybersecurity program shall be based on the covered entity's risk assessment. So again, I think that they kind of flip the dates here a little bit. You know, we'll give them a pass, but we're interested in reducing your risk, helping you be secure at the same time. So take our advice, the risk assessment should be done first. Okay, so these are just some of the dates, just to keep a mental snapshot of. If anybody's interested in the slide deck or the notes or anything after the fact, we can provide that to you as well. Now this whole thing, and you see on the right here, this is the New York State Department of Financial Services. Does that mean I need to be in New York State for this thing to apply to me? And the answer is a big no. So I have a map here of the United States, and the reason I have that is because we have clients signed up for programs, for security programs in a lot of different states. I had people from Florida giving me calls, people from Massachusetts, people from all over the place saying, hey, I'm not physically located in New York State, but we are licensed to do business in New York State under the banking, insurance, or financial services law, so I need to comply. Can you help me comply? And I say, yes, we can. So again, just because you're not in New York State doesn't mean that you get a free pass here. It's about being licensed within the state. So again, it's not your domicile that affects your needs to comply. It's the fact that you do business in New York State that matters. So really, I don't go about anything in life without answering the question, why am I doing this? And we talked about that a little bit in an earlier slide. The why is because that 2013-2014 survey showed a large majority of institutions under DFS are not doing a great job on cybersecurity. They found a lot of risks. They found people weren't budgeting for cybersecurity. They were sort of throwing money at the problem, but not really having a coherent plan. A lot of organizations weren't having regular penetration testing done. And, you know, that obviously rose some red flags. So really, the purpose of the new regulation is to protect consumers' private information while also helping covered entities to stay in business, right? So if you're of the mindset, okay, let me get this thing out of the way, check the box, be in compliance, and then move on going about what I do, that's really a poor mindset. You also have to consider all the breaches and things that are going on lately with Petya, with Crypto Locker, all these different types of ransomware that we're seeing these days. It's not just about checking a box for compliance, but there's also that dual goal of having a secure organization where I'm not ending up in the 6 o'clock news. I'm not ending up having to write letters to my stakeholders telling them that their information was lost, and now I have to protect them with Lifeguard or things like that. So again, there's compliance, but there's also the security aspect as well. So by putting these policies and controls in place, organizations are able to mitigate risk and be proactive in their approach to cybersecurity. They're able to reduce the likelihood of a breach or unauthorized disclosure of private information. So I like that, you know, am I a fan that New York State is a highly litigious state? No, not in general. But I am happy that they're more concerned about the security of consumer data and reducing financial impact to DFS regulated industry entities than simply about checking a box to be compliant. So that I am happy about. So again, while it may be okay to hurry up and get compliant at first, doing the things that it says we need to do, I think organizations should shift their mindset to one of security over compliance. After all, we're ethically bound to be good stewards of the consumer data that we ingest, store, and transmit. Going back a slide or two here, if you look on the bottom, the 3 up from the bottom, we see encryption of non-public information. There's a lot to do these days about how to encrypt. I just want to make a point here on encryption. There's 2 ways to do it, whole disk and file level encryption. And we're really, both have their merits, and you should consider both in the use cases. So whole disk encryption, for example, I have a laptop, I wrap an encrypted container around it, whether it's BitLocker or Sophos Safeguard or some other solution. That protects against somebody smashing and grabbing my laptop out of the back seat of a cab. Okay, so that's good. If I have protected information on there and somebody grabs a laptop, tries to take the hard drive out and put it into their system, it's useless to them. So that protects against that. However, most of the time, your laptop won't be in the back seat of a cab. It'll be running on your desktop with you logged into it. And at that point, whole disk encryption really doesn't do anything for that type of threat. At that point, file level encryption is the more important thing. So file level encryption deals with, let's say I get a malicious PDF or some kind of drive-by download that makes it past my edge and endpoint defenses, and now it's on my system. So I've got malware. Now it's trying to go and, let's say, take protected files out of the network and ship them off somewhere to a command and control server. That's all fine and dandy. They can take my files. If I have file level encryption at that point turned on, no matter what they do with the files, it's useless to them because they don't have the decryption key. So consider both types of encryption. And then multi-factor authentication, just to retouch on that, it is a sweeping regulation in that it's requiring that. There's many options from cloud-based to on-premise, and we can talk offline about that if anybody has any questions or needs to be steered in a certain direction. All right, so again, we talked about there sort of being two buckets for compliance. One is the limited exemption, one is the non-exempt. In both buckets, though, is the core risk assessment in section 500.09. All right, that risk assessment is going to help us discover existing organizational and technical gaps, as well as vulnerabilities and risks to your critical systems and data. The findings from the risk assessment then feed into and inform the cybersecurity plan going forward. So we're really creating a remediation roadmap for you, not only in 2017, but for 2018 and so on and so forth. The DFS regulation doesn't say you have to immediately have a perfectly functioning network with zero risk. It would be silly if they tried to say that. So the regulation is not saying take your risk and make it zero. It's saying know your risk and have a plan to reduce it. And so that risk assessment is going to serve as the roadmap for doing that. So, okay, Jeff keeps saying risk assessment. What does he mean? The way that we carry out these risk assessments, it starts off with a vulnerability assessment. So we use some specialized security scanning software. We pointed at your workstations, your servers, your routers, your switches, anything that's IP connected, that's active. We're looking for things like unpatched systems, misconfigured services, outdated versions of things like Apache or OpenSSL or Adobe Flash Player, Adobe Reader, things that are going to allow hackers to get in and cause damage or steal data. So we're looking for those things first and foremost. But it's not just a technical thing. We're also doing departmental interviews. So if you have 5 departments or 10 departments or even 2 departments, we're going to talk to those key stakeholders in each of the departments to find out their general awareness of the policies and procedures in your organization, to find out what they're doing on a day-to-day basis in terms of ingesting data, storing it and transmitting it, what workflows are involved, will follow NIST standards for that. And those are federal standards. After we do configuration reviews, we do sort of what-if scenarios where we go through thought exercises. We say, what would happen if you lost your primary and only site? What would happen if you lost your DR site? What would happen if you lost internet connection, power? What would happen if you lost a key stakeholder within your organization with a high level of knowledge that maybe wasn't shared to other employees? So we go over these sorts of what-if scenarios, and that makes it real to people, the sorts of risks that would be inherent in their environment. And then the output from all of that, we tie it together, and create a cybersecurity policy, which is going to be, again, going back to what I said, the roadmap for reducing risk going forward. Once we have the roadmap, we can then tackle those 14 policies that we talked about in an earlier slide under section 500.0.03. From there, we can then make technology decisions. Do we have encryption on? Yes or no? If we do, is it configured properly? If we don't, well, what do we need to purchase? What are the options out there? Same thing with penetration testing. Incident response in third-party vendor management policies are important as well. Do we do this CISO role in-house, or do we not have a qualified individual for that? So these are all questions that we look at based on the risk assessment. So again, it's going to be smaller for the smaller organizations. It's going to be more effort for the larger organizations. But it's very important that I think we do these things up front, and then maybe start to open the conversation with your in-house IT staff or whoever your IT service provider is. That's the gist of it. I wanted to open it up to questions and answers. So if you have questions about any part of the new cybersecurity regulation, it's best to also contact the DFS, and I've got their phone number on there as well. We are industry experts from the cybersecurity perspective. We've done numerous projects to help organizations become DFS compliant. So you're not guinea pigs. All of you on the phone know that we've done this many, many times for people, whether they're limited, exempt, or not. That being said, again, we can help you get through any of the steps or any of the sections of the law, and whether it's just reviewing what you have, whether it's doing a risk assessment, helping with policy, penetration testing, all that stuff, we've got modular options available so that you can select only what you need. If you've already got somebody doing pieces of it internally or even a third party, we don't need to overlap. We don't need to force you to do that stuff through us. But if there's stuff that you're not doing and you've jotted it down based on today's presentation, please reach out to us after the fact. That's all I have, so I just want to leave it open for questions and answers. If anybody has any questions, we'll take some quick questions and answers.
Yeah, this is Patrick. Thanks so much for the content, very helpful. I'm going to unmute the lines here, so hopefully I do this correctly. And so hopefully folks can ask any questions they like. So hopefully your line should be unmuted. So if anyone has any questions, ask away.
Hey, Jeff, does the DFS specify anything around continuous monitoring? Uh-oh, are we muted? I don't know. Hey, Jeff, can you hear me?
All right, yeah, I can hear you. Okay, so the question was, go ahead and say that again.
Does the DFS specify anything around continuous monitoring?
Yeah, so that was a question a lot of people had up front, and I mentioned earlier we worked with a half a dozen different lawyers on really what does it mean continuous. And the question they brought was, well, does that mean I need to have a butt in a chair sitting there constantly looking at a screen, going through logs, you know, babysitting all the information systems that I have, and maybe I have a SIEM solution that's integrating different logs from different systems. And the answer that we all kind of came up with was no, the law doesn't get into that level of specificity. So what they say on their FAQ site, and I've got the link up here, is that they say that effective continuous monitoring could be attained through a variety of technical and procedural controls, and that there's no specific technology that's required. Okay, so they really do leave it open to interpretation, and that's why it's highly important to have, you know, a trusted cybersecurity company to help you. there's a number of ways to skin a cat. There's a number of ways to do continuous monitoring. At a bare minimum, if you have a firewall, that firewall can be turned on to send emails out to a distribution list upon a certain level of criticality of event, through the IDS IPS engine on it. At a bare minimum, that should be done. On your workstations, at a bare minimum, if an endpoint detects that it's infected, it should be able to alert an administrator at a bare minimum. So those are basics. As we go up in scale, the larger the organization, the more there is at stake. We want to start thinking about SIEM solutions where we're aggregating logs in-house, whether it's a syslog server or a full-blown SIEM solution. We need to have a way to take the noise and kind of reduce the noise level, make sense of it, and only output on those things that are actionable. That feeds into notices to superintendent. We are required as covered entities to notify the DFS, the secretary of the DFS, within 72 hours of a suspected breach. And when we say suspected, if we're getting an email notification or if it's entering its way into a logging system, it's at a certain criticality. If we go and look at it and believe that maybe I've got breached, maybe I'm not fully sure, it's best to just notify the superintendent anyway. What do they do with that information? They haven't told us yet. We just know that we're bound to, and it's our duty to notify within 72 hours. So again, we're not talking about continuous monitoring, isn't talking about somebody continually sitting there. As long as we have a systematic way of getting logging information or alerting information, whether via email or otherwise, to the right parties who can make sense of it in a timely fashion, then we're doing a good job on continuous monitoring.
Thank you.
Cool, thanks, Jeff. Anyone else have any questions? Hopefully I correctly unmuted everyone, so everyone should be able to speak. All right, well, thank you so much, everyone, for joining our call today. Jeff, thanks again for the helpful information. Hopefully this was definitely helpful for the folks on the phone. We have, as Jeff had mentioned, we do have a copy of the presentation. We also recorded this session, so we'll send this out as an updated content available, which you can share with folks with your organization or other folks as well. That concludes today's webinar. I look forward to talking with everyone in the future, and I appreciate everyone's time, and take care.